I don't know. After hearing him calm and talking about the tether story, it's probable.
Just go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
What's going on? This is Colin. How's everybody doing? Happy Sunday. Got a good collection of clips for you to roll into the start of the Bengals game. Hooday. If anyone's out there is a NFL fan, I hope your team wins, unless you're an AFC North team not named the Bengals. That was a mouthful to say out loud. But yeah, AFC North killing it this year. And yeah, the only team I care about is the Bengals. So I'm sorry if you're in the AFC North with the Bengals. Anyways, I've said Bengals too many times. Before I get started, had a super chat from Lynn after I got off last night. Thank you so much, Lynn. I appreciate it. And her comment was for the Heather Silky Leg Fund. I really hope that doesn't become a thing. I don't want to do that. But, I mean, maybe you guys want to see it? I don't know. Good morning, everyone in chat. Hey, Jay. Jay's always around. Scaff, Heather, Melanie, Phil, who did I see? Glitterfart, Sashina. Sashina has the next chapter of her book coming out at noon. I didn't mean to start this and overlap her. I was just trying to get this out before the Bengals game, so I'm sorry, Sashina. But please drop your link so we can all go watch it after this. Or if we want to go watch it during this, I will not be offended. All right. Think that's all I had to ramble about. But before I hit the play button, you already know what to do. Like and subscribe, do your jump kick backflips. And if you want to donate, Linktree's down in the description. Also, Discord's down there. Come hang out with us. Let's go.
Mr. Wilson, are you able to hear me okay?
Yes, can you hear me?
I can, thank you. All right, we're on the record now in People versus Wilson. We have a number of files up for hearing today. I'd like to start with the newer files related to sentencing, and that is file 235-240 and 5241. We also have some probation violation files that we're hearing, but I'd like to address the sentencing first. I can have both counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Honorable Gurumurthy. I'm appearing on behalf of Mr. Wilson. I'm appearing by Zoom. Mr. Wilson is also appearing by Zoom. And Mr. Wilson does not object to proceeding to sentencing by this manner.
Thank you. This is the date and time set for sentencing in this case. Mr. Wilson, have you had a chance to go through the pre-sentence report with Mr. Gurumurthy and talk to him about that?
Yes, Your Honor.
Are you ready to proceed with sentencing at this time?
Yes, Your Honor.
Thank you. Mr. Gurumurthy, are there any additions, deletions, or corrections to the report?
No, just for the record, I did send the pre-sentence report to Mr. Wilson. He did get a copy of his entire report. So I just want to put that on the record. And then we did review some of the contents of the report. And based on that review, we don't have any additions, corrections, or deletions to the body of the report.
Thank you. Do you have any challenges to the scoring of the guidelines?
No, sir.
Ms. Pope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Do the people have any challenges to the scoring of the guidelines?
No, I think they're correct.
Anything on behalf of the people for allocation today?
Your Honor, we're going to ask the court to sentence Mr. Wilson on the high end of both cases, which is 23 months and 24 months. And I'd ask the court to do consecutive sentencing. The court is very familiar with Mr. Wilson at this point. He has a prior, I think he previously had to be extradited from Florida. And we had the cases where Your Honor gave him a great offer. I was looking to look at my notes, but I think we may have even went under the guidelines last time when he had 5 felony cases here and 2 were dismissed and he had 3. The court gave him a year in jail. I remember us talking about his work ethic and how he was trying to get clean and do the right thing. Since then, he's had 12 probation violations on his other files. Between the 3 counties, he's got felonies everywhere. He absconded. The court's aware of how he absconded. Hours and hours of time were spent um, trying to locate him and to follow up on the forged letter that he provided, because he didn't just abscond. I don't know who forged the letter, so he wasn't charged with that, but a letter was provided to this court and the other courts with this forged signature. Mr. Wilson has earned a prison sentence. I don't think boot camp is appropriate for Mr. Wilson. I'm surprised he hasn't been to prison yet, but he has 6 prior felonies, 22 prior misdemeanors, and a juvenile record, and he's only 34 years old. So I'd ask the court to sentence him on the high end of the guidelines. And I believe based on all the facts that the court's aware of, consecutive sentencing is absolutely appropriate. Thank you.
Thank you, Mr. Gurmurthy. Anything on behalf of Mr. Wilson today?
Yes, Judge, Mr. Wilson is 34 years of age. Mr. Wilson, as the court is aware, has a prior criminal record. But I think the court should know where Mr. Wilson currently is. I think he's in a much better state of mind than when these offenses were committed. As Mr. Wilson states in his pre-sentence, that he knows he messed up. He knows he got into these criminal charges because he was not in the right state of mind. But I think since then he has cleaned up his act. He resolved all of his matters pending in different counties in Roscommon, Otsego, and Crawford County. Mr. Wilson, I don't believe is eligible here for a consecutive sentence, but I don't believe even that the offenses are that severe, given that they should warrant for consecutive sentence. The idea with Mr. Wilson at this point would be to punish him for the crimes that he's committed, but also give him that opportunity to rehabilitate himself. I understand there have been some prior probation violations and the absconding issue, but I think that's all in the past for Mr. Wilson. He accepted accepted the plea, accepted the sentence that would come with him, knew at the time of the plea that this would come with a prison sentence. But Mr. Wilson is asking that the court give him that opportunity to rehabilitate himself, give him that opportunity to show that he is going to work through programs while in prison. He is eligible for boot camp, that the court grant that boot camp eligibility. Certainly the court doesn't have to grant it right away. The court could grant it, 14, 15 months out after he does a prison sentence, and then reintroduce him into the community. Because again, while on boot camp, he would be on a parole detainer status where he still has to, behave while he's out. And if he violates, he goes back to prison. He has to then finish up his term and potentially have new charges that would then be consecutive to his parole status. So there's a lot of, I think, benefits here for Mr. Wilson, that if the court does grant the request for boot camp, that he doesn't mess that up. He doesn't make that worse for himself. But that would be the idea, is to give him that opportunity for rehabilitation. I know part of this plea agreement was that the misdemeanor file would be dismissed and that there be restitution ordered to Ms. Brandy Welch. Mr. Wilson does not object to that restitution amount. And I did submit some letters on behalf of Mr. Wilson that he has support of his family and family members around. So I would ask the court to give him that opportunity towards rehabilitation by granting him boot camp after a certain time frame that he does while he's in prison, and get some classes and some other skills under his belt. That's all I have, Judge.
All right. Before we go too much in, I am not speaking clearly this morning. Before we go too much further into this, can someone explain to me what boot camp is? I don't know what that is. I mean, I know what military boot camp is, but this isn't the first time I've heard a court refer to a program called boot camp. Is it a drug rehab type of place? That's what I'm assuming, but I really don't know what it is. Also, Amanda, thank you so much for the super chat. I appreciate it. Very generous. All right, let's go.
Thank you, Mr. Wilson. Was there anything that you wanted to say here today?
Well, I don't agree with what was said at sentencing yesterday, as all the mothers of my children would feel the same way as Ms. Dazinski, because I do support my other 2 children regularly. I don't have warrants. I've never been to jail on those matters. I'm finally admitting I have a problem and taking responsibility. Normally I would be in jail. I would tell myself, how can I hide it better? How can I get away with it? That's not the case this time. I just simply don't want to go down the same road over and over. If rehabilitation is what's needed, and clearly my drug addiction is the problem, how is a long prison sentence what's needed for my recovery? As I've been here for almost 2 weeks and I've been approached by inmates asking if I need or wanted prescription drugs, alcohol, meth, cocaine, heroin, and fentanyl, Suboxone. I believe the system to be flawed and boot camp to be a safer place. I do believe I need time to reflect. I also asked the judge to reconsider boot camp for its structure and discipline and possibly be approved for it after I do a year in MDOC or even half my sentence. They have intense inpatient substance programs in the program. They require no sanction or tickets of any kind and must complete all courses to graduate. And drugs and alcohol is zero tolerance as they drug screen throughout the program, and inmates don't leave the compound as they do in prison. I've done my research on this, and I believe the program is the best interest of the court, my family, the homeowners I do work for, and also myself, and to show that I'm not just another statistic. And so I can prove to the courts and you wrong about who I am. Thank you for your time.
Okay, thank you. The court had a chance to review the pre-sentence report in these files here today. As hold on one second. As Mr. Wilson, for the record, I'm just muting Mr. Wilson only because there's some background noise there. Mr. Wilson, if you need to address the court again or want to, or need to speak with your attorney, just raise your hand and I'll unmute you, but there's a lot of background noise there that's interfering with the record. So again, the court's had a chance to review the pre-sentence report in this case. I'm familiar with Mr. Wilson. Mr. Wilson was in front of me yesterday for sentencing on some other files in Otsego County, and some of the statements were referring to the sentencing hearing we had yesterday. And I do adopt some of the statements that I made in the course of that hearing. Generally, of course, the circumstances here are different crimes in a different location involving completely different circumstances. But I say that to say that I am familiar with Mr. Wilson, his past history, his background, as well as the cases here. Mr. Gurmurthy is correct. I did receive a number of letters on behalf of Mr. Wilson. I did have a chance to review those letters prior to the hearing today. Yesterday, one of the victims in one of today did speak favorably on behalf of Mr. Wilson in terms of some aspects of his character, in terms of his ability to work and so forth. So the court takes all those things into account along with what Ms. Koch has had to say. And certainly I you know, in this case, the court is looking more at a punishment aspect. I understand that may not, prison time may not result in rehabilitation, but I think given Mr. Wilson's conduct, that there needs to be a component of punishment and deterrence here. There have been numerous opportunities through probation, through community sanctions for Mr. Wilson to take advantage of programs to correct his behavior, and none of those things have worked. So in my view, it's time to try something different, and the only real option left to the court is prison time. Yesterday, I expressed that I didn't think boot camp was appropriate, and I continue to agree or feel that way. I think given the number of crimes, Mr. Wilson's past history, previous attempts at rehabilitation, at this point, again, I think the court needs to focus on a punishment forward sentence as opposed to rehabilitation. However, although I do think consecutive sentencing is allowed in this case, discretionary because of Mr. Wilson's bond status, I think there are mitigating factors here as reflected in the letters of support for Mr. Wilson. So while I don't think boot camp is appropriate, I also don't think the extreme sanction of consecutive sentencing is appropriate either. I think a sentence at the high end of the guidelines here addresses his previous conduct or his previous record and conduct, as well as his conduct in these cases. As to file 235240, the court will sentence Mr. Wilson to 23 months to 10 years in the Michigan Department of Corrections. Mr. Wilson on that file has 101 days credit. Restitution in the amount of $416 payable to the Crawford County Clerk. Crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. As to file number 5241, which is the absconding charge, the court sentences Mr. Wilson to 24 months to 4 years with credit for 56 days served. The crime victims assessment of $130 and the state cost of $68. Those sentences to run concurrent to each other and concurrent to any other sentences that Mr. Wilson may be serving. Mr. Wilson, you will be provided with an acknowledgement of your appellate rights. Those papers will explain to you how to seek an appeal of these sentences, as well as how to request a court-appointed lawyer to help with any appeal. Mr. Grimmerthy, is there anything further we need to address in terms of sentencing on those two files?
No, Judge.
Your Honor, I just want the court to acknowledge on the record so that we have it for the record if we need it. These sentences are concurrent to both Roscommon and Gaylord's prison sentences. They have to be because this was first in time anyway, but I think we have to put that on the record.
And I did say that they would run concurrent to each other as well as to any other sentences that Mr. Wilson has served.
Thank you.
In terms of the probation violation files, 4695, 4696, and 4717. We have Mr. Haven here present on behalf of probation and parole. Mr. Haven, how did you want to proceed on those files today?
Well, Your Honor, despite all the violations and violation behavior that he has exhibited, having done no less than 12 warrants being signed by Your Honor, he does have about 407 days of jail credit regarding the probation files. So in light of that and the prison sentences that he's serving, I would ask the court to dismiss the violations.
All right, Mr. Grimmerthy, anything that you wanted to state for the record in that regard?
No, Judge, as to the probation violation files, all of them, my understanding was that that was going to be dismissed. But I know Mr. Wilson wants to address the court, Judge. I see him raise his hand.
I'm sorry, I didn't see that. Hold on, Mr. Wilson, go ahead. You might have to press something on your end there.
And also, Your Honor, to recommend discharge unsuccessfully on all three files.
Oh. Okay, Mr. Wilson, we're able to hear you now.
Yes, now, I don't know if I address you or if I address Ravi about how long and how much credit, because I got 16 months in Crawford, 28 in Gaylord, and 24 at the most in or Crawford, 16 in Roscommon. With so many days credited, I mean, how much time does that break down to? It's crucial for my business. I still get phone calls about estimates and work.
I think that's something that you would have to address with your lawyer, Mr. Wilson.
Is there any possible way we can go into a breakout room after the court's done with me?
I can do that, but I have Mr. Grimmerthy, I need to have him address one other hearing before we do that. So I can put you in the waiting room, and then when he's done, I can put you two into a breakout room.
Please and thank you.
Okay. All right, so the court will order that the current probation violation be dismissed, that Mr. Wilson be discharged unsuccessfully from probation in each of those files, and that any outstanding fines and costs be preserved. And then, Mr. Wilson, I'm going to put you in the waiting room for a minute, and then I'll have you talk to Mr. Grimmerthy.
Thank you, Your Honor.
Hey, they're not the Bungles anymore. That was in the 90s and the early 2000s. They're getting their act together. So, yeah. Them be fighting words, one more thing. Still appreciate the comment, though. Oh, what else was I going to say? Oh, happy birthday, Sally. Birthday's tomorrow. Everyone say happy birthday, Sally, please. She's been a fan of the channel since almost day one. I've seen her name pop up a lot. So, happy birthday, Sally. All right, next one. I believe this one was from yesterday. This is a fun one. I like it. It's fun. I'll comment more after this, but let's go.
Westland. All right, Ms. Shive, I've got Dearborn Heights.
Yes,
Ready?
sir, ready.
What was Mr. Quartz's client's name and what case?
Susie Bradley. Mr. Quartz's client was Paxton from Taylor.
Okay, all right. All right, that's Dearborn Heights. Officer, state your name.
Sergeant Derwick, for your record, Your Honor.
All right, good afternoon.
Good afternoon.
All right. Is this Elijah Lake?
This is Susie Bradley.
Susie Brandley.
This is Dearborn Heights.
Oh, I've got Dearborn. I'm sorry.
What's the name of her?
Susie, what's the last name?
Bradley.
Stop talking.
They're asking my last name. I can talk if I want.
I'm not talking to you.
Give me one moment.
Can you mute us, Your Honor?
I'm sorry. Can you, oh, yes, I can. Okay, give me one moment. Hold on.
They left. Where'd they go, attorney? Attorney,
Oh, I'll be back.
where'd they go?
They just need 1 minute, okay? They just need 1 minute.
Should I be quiet?
Yeah, please. Everything's being recorded. Just let me do the talking, okay?
Okay,
Thank you.
thank you. You're welcome.
She's fun. She's fun. They do say that, you know what? I'm not gonna spoil it. But I bet she's fun to work with. They'll say what her job is.
You like my jacket?
Talking to me or her?
You. It says vape on it.
What's that mean?
That means it's the kind of hoodie I have. The
That's
vape,
the brand.
the brand.
What's
You
that?
like the brand? Vape.
What's that mean?
It means vape.
What's this one mean?
Oh, this thing?
NHPO?
NBHD.
What's that mean?
NBHD. No bitches, hoes, dick.
It's great.
I know.
I love the officer too. That's great. That's great. You know, if you're nixing out those three categories, you're really limiting the field for yourself. I'm telling you. Gotta experience a little bit more. This isn't anywhere close to over.
Means no bitches, hoes, and dick.
Okay. Let's not say that.
Miss Bradley, it's all part of the record right now, okay? We're still in
I know
court.
I'm being
So
recorded, I know.
don't say anything.
I'm not
okay?
saying anything inappropriate.
Just don't say anything at all.
Okay, thank you.
For your own protection, okay? Thank you.
Thank you. You're welcome.
All right. My apologies. Dearborn Heights, we're ready.
No problem, Your Honor.
Susie Bradley, correct?
Yes.
All right. This warrant has been signed already by a magistrate. So we're just here for an arraignment.
That's correct.
That's correct? Okay.
Yes, sir.
All right. Calling case number 822-37084-9901. People City, Michigan versus Susie Ruth Bradley. Appearance, please.
Hello.
Jessica Scheib on behalf of Ms. Bradley, who waives from a reading, understands her constitutional rights and stands mute.
All right. The court recognizes guilty plea on behalf of Ms. Bradley. Ms. Bradley, I'm going to ask you to do two things, okay?
Guilty.
Okay, ma'am, Ms. Bradley, I'm going to ask you to do two things. First of
Okay.
all, remove your hoodie. That's going to be three things. Second of all, stand still. And third of all, state your name for the record.
Susie Bradley.
Okay. Go ahead with your argument as the bond, Ms. Scheib.
Why does standing still mean she stands like that? I don't know. I don't know, but I cannot stop laughing. This is, I think, the third time I've seen this.
Your
You can
Honor,
put your arms down. Thank you.
Your Honor, she lives with her grandma. This incident allegedly is from April. It has some little bit of age to it. She does not know the complaining witness. There shouldn't be any issue with the no contact. I'm not aware of any contact in the months that have passed. She's employed at Qdoba. She's 18 years old. She does suffer from mental illness, Your Honor. She is on medication for that. I'm respectfully asking the court to release her to her grandma's house so she can get the proper care that she needs, Your Honor. And I'm not sure, Your Honor, if there's a capias, I'm sorry, or a cash bond set, because this is from April. But if there hasn't been, I'm respectfully asking for a high personal bond and allow her to be at her grandma's. If the court is not inclined to do that without a tether, then I ask for no restrictions, but I just want her to be at home, released to her grandma. I do have her grandma's contact information so she can continue her medication and be under the proper care, Your Honor.
All right, officer, your thoughts and recommendations as to bond?
Well, just to let you know, Your Honor, this is a failure to appear, so I don't believe she has any intentions of taking care of this matter. But I'm
So
not.
what was the capias bond then?
I'm gonna go to court.
Well, she was originally arrested on this case, Your Honor, and
Right.
she was arraigned at the 20th District Court back in April, and she received $1,000 10% cash bond. I'm not sure if that bond was paid
It was.
or if she was just released.
It was.
I'd have to
paid.
check with the court on Monday.
Miss Bradley, please be quiet. You said that bond was $1,000, 10%?
Yes, Your Honor.
And it
That was the original.
paid.
That was the original bond, correct?
That's correct.
And she failed to appear for a prior court date.
That's correct.
And when was the prior court date?
August 7th.
Give me 1 second, Your Honor.
Okay.
I just have to go through the investigator's notes who handled this case. That's even if I have it with me, Your Honor. I don't believe I do have it, but typically
Okay.
it's as you know, about 2 weeks after the arraignment. So probably sometime in May.
I like my mugshot.
Yeah, I don't have that record with me, Your Honor.
It's August 7th. Just so you know, it's August 7th.
Why didn't you appear?
Because I tried to call the courts and they wouldn't tell me which court I had to go to, but I knew it was August 7th. But I didn't appear because I didn't know which court or what time.
You could have gone up there that early in the morning and done all that instead
I
of calling.
didn't know I could. I didn't know. I was
Alright.
kidnapped. I
You were
was
kidnapped.
kidnapped.
All right. All right.
Yeah,
All right. All right, Miss Bradley. I want to make sure you're not kidnapped. You're gonna. The
I'm not
court's going to just listen while I'm talking. You listen, please.
Yes, sir.
Thank you. The court's going to reinstate the original bond, $1,000, 10% cash bond. No contact with the complaining witness. If you're able to post bond, I want to make sure we're able to track you just in case you're kidnapped. You'll be fitted with a GPS tether, no restrictions, other than
No, I don't.
other than the no contact provisions.
Can I get out?
Yeah,
For
with a
free?
tether. No,
For
no
free?
free. No free. Nothing's free for you today.
Your Honor, the bond was 1,010%.
Yes.
Okay, Miss Bradley, I'm gonna call your grandma, okay?
She's not gonna pay $100.
We'll
She
figure it out.
just kicked me out. She just
Oh,
kicked me
okay.
out yesterday.
Okay, Miss Bradley, please don't say anything else.
Okay, Miss Bradley,
Yes?
please can you be quiet, please?
I'm gonna let my
Officer,
lawyer.
All right, Miss Officer, when was she arrested?
I believe she was arrested yesterday. She was picked up from another jurisdiction.
Ann
picked her up,
Arbor.
And she was brought
Okay.
here.
All right, Miss Bradley, your probable cause conference is November 22nd. Preliminary examination November 29th at 20th District Court in Dearborn Heights.
So
We'll have
I'm
to
gonna
post
go to
$100
Wayne.
you will have to post $100 to get out, and then once you're released, you'll be fitted with a GPS tether. You have no restrictions other than no contact with the complaining witness.
What time do I gotta be home on my tether?
Just show up for court. Have a good day.
I will.
Thank you, Your Honor. Have a good day.
Thank you. Have a good day.
Thank you.
Call for my bond.
Have a good weekend.
I'll try.
It is not over yet. I left one comment
What
from
are
the
you ready
judge
on
still
next,
in there.
Miss Shai?
I'm ready on Garden City, which is Eunice. They're on and ready. I'm ready on Dearborn.
Garden City hasn't.
They're. I think that's them. GCPD.
Yeah, they're just not unmuted and whatever.
Okay, let me try giving them a call.
Okay, you know what? After that last one, I need a couple minutes break.
Okay, Your
I'll be
Honor.
right back.
Okay, thank you.
I loved it. She was a hoot. I really enjoyed her. She couldn't stop talking, but I don't know. I don't think she's a danger to anybody. She just I don't know. What was I gonna say? Oh, she works at Qdoba. After spending at least half of my life in a restaurant, I bet she's awesome to work a kitchen line with. I just do. She would be fun. She would make work interesting, that's for sure. All right. The next one was a bonus one I threw in. Yeah, let's watch it together. I don't remember what it is, like always.
Ms. Rico, were you in the courtroom when the video containing your rights was?
This one's sad. Just a forewarning. The last one is better, but this one's sad.
Played?
I'm sorry, what?
Were you in the courtroom this morning when your rights was played on that video?
Yes, I was.
Did you understand the rights contained in that video?
Yes, I do.
And did you understand the maximum possible penalties associated with misdemeanor crimes?
Yes, I do.
Did you have sufficient time to speak with your lawyer this morning, Mr. McGinnis?
I did, I believe.
Okay, if you need more time, you let me know while I take you through these cases. I'm going to first place this on record in 23 CR 05648. In this case, Judge O'Neill placed you on a suspended sentence. Specifically, on August 31st of this year, Judge O'Neill imposed 30 days in the Washoe County Jail, but suspended that for a period of 1 year. Conditions are that you complete a DUI level 2 class. That's 13 weeks of counseling. You were to also complete a parenting class, obey all laws, consume no alcohol or drugs without a prescription. I want you to know that if you're convicted of any new charge, including this new DUI you face, or you're found in violation by having consumed alcohol, or you didn't complete the parenting classes or the level 2 DUI classes, you could be found in violation of that suspended sentence, and that suspended sentence be revoked. Do you understand that?
Yes, I do.
All right. I'm going to put that aside for a minute. We're in 23 CR 13893. In this case, you were charged with driving under the influence of alcohol, a first offense. This alleged to have occurred on November 7th of this year. Do you understand that charge?
Yes, I do.
How do you wish to plead to that charge?
Not guilty.
I accept your not guilty plea. We're going to set this matter for trial. I have reviewed this case this morning for probable cause. I do find that probable cause does exist to support the charge and the arrest. Let me look at the document that I need next. do qualify for the appointment of counsel. Would you like me to appoint an attorney?
Yes.
Legal defender is appointed. Let's get you a bench trial date and then we'll go over your custody status.
Okay.
And Judge, you said legal defender was appointed, correct?
Yes.
I have December 21st at 1 p.m.
All right, thank you very much. December 21st at 1 o'clock in the afternoon is your trial set on this matter. That'll be in the Reno Municipal Court. And like I said, you will have counsel assigned to represent you. Now we're going to go to custody status. Ms. Schuman.
Your Honor, we're requesting a monetary bail of $3,500 bondable. Definitely concerns about her alcohol consumption. She was just sentenced on a domestic battery case where she battered her 17-year-old son. That was about 2 months ago with that no drugs or alcohol clause. Now here we are with the DUI. It looks like she abruptly stopped, a vehicle rear-ended her, and then she took off without providing any information. She was described by the other drivers being aggressive towards them. Officers ended up finding.
Just for you. I'll do this just for you, Richard. I'll take my little screen away.
Her at her house. She refused the PBT. Search warrant had to be obtained. So I'm not sure of her blood alcohol level. NPRA scored a 5. So given that, Your Honor, we felt monetary bail is appropriate.
All right, thank you very much, Ms. Schuman. Mr. McGinnis.
Thank you, Your Honor. I did review the Nevada pretrial risk assessment. It does score her a 5. I think it's probably not accurate because she does have a stable place to live. She does have a full-time job and she does have a cell phone. Problematic is her suspended sentence that occurred on 8/31 of this year, where she was actually found guilty of obstructing and resisting. I was her attorney on the obstructing and resisting and the domestic battery, so I'm very familiar with Miss Rico. One of the reasons why we pushed her case out and got the substance abuse evaluation is because alcohol is problematic for her. Positive things about Miss Rico, Your Honor, is that when she was on supervision on her domestic battery obstructing and resisting case, she was with Sober 24, and from May to November she was compliant with Sober 24. May until August she was compliant with Sober 24. She did not have any mishaps at all. She was then placed on that suspended sentence in August, and that was approximately 3 months ago. This is her first slip up, her first time drinking alcohol since May of 2023. She's really been trying to address her alcohol issues. However, she certainly slipped up here. Another positive thing is that she was doing her alcohol classes. She's done 8 of the 13 that she was required to do. So she is a single mother, moved here approximately 3 years ago, got divorced. She has 2 high school kids at home right now by themselves. She wasn't able to pay the power bill yesterday. She thinks the power went off. She's not exactly sure what's happening. She's a full-time hairdresser. She works, I believe, at Supercuts out in Lemon Valley. This is the individual that was successful before on pre-trial, an individual that tells me that she doesn't have any money to bail out. She asked me to ask the court for an OR release, which I was hesitant to do, noting that she had that suspended sentence. However, she wanted me to ask if you could do that and place her on enhanced supervision. I think this is probably going to be tracking to a fresh start case once we can get the DUI and review it. There was a blood draw, it was a warrant, so we don't know what her blood alcohol is. The field sobriety test, only the HGN was done, and there's no PBT. So at this point in time, I advise her to enter a not guilty plea to the DUI. But I think this is going to be a fresh start program, is what I'm posturing for.
Thank you, Mr. McGinnis. All right. Ms. Rico, anything you'd like to say only with regard to how I release you, not about the facts of the case at all?
Yes, I do have my 2 kids at home. I'm very, very concerned for I'm their only primary caretaker. I have full physical custody of my kids. Their father's not involved in their life. I did have a power bill that was due yesterday that did not get paid because I was not there to make the payment. So I'm very unsure if the power is even on. And I can't get a hold of anybody and I don't know what else to do, but I just do know that I slipped up, I made a mistake, and I am trying my best to be in compliant with everything that I've been going through and, you know, all the classes. I have a class tomorrow with NCCT, the counseling service. It's at 6 o'clock. I have that, which they're scheduled every Friday. And I'm just asking for some understanding, and please let me get home to take care of my family because they are all I have. I don't want to lose my job.
And Your Honor, if I may just, I hate to interject, but if you look at the MPRA, her first arrest was in May. She had no criminal history prior to this. I think the divorce hit her pretty hard.
You give me a difficult situation in this one. Let me tell you, Ms. Rico, that I consider you a risk to the community. At the end of the day, you're on a suspended sentence that prohibits you from drinking. You got 30 days of jail hanging over your head. Then allegedly you come out and you, not only do you drink, but you commit a DUI, and that's the concern. And so you're at an increased risk, in my opinion, to the entire city. I don't think you're a risk for failing to appear for court. That's not the risk I have to protect, but the city's interest, the risk that I have to protect against is your ongoing risk to the community. And that's what I have to concern myself with. You know, look, I could theoretically, the law provides me the opportunity. I'm not going to take it at this point. I could revoke you right now on that 30 days for having consumed alcohol. I don't even have to wait for an obey all laws violation. I can say you drank and I'm going to go ahead and revoke you and you spend 30 days in jail. Those are the consequences you face by taking these actions. And I'm looking at the PC and your daughter is saying it's because you drink. Your own daughter wants you to stop drinking. How old are your kids?
16 and 17.
Yikes. What are they doing to make it happen at this point? You don't even know, do you?
I don't know.
And there's no one else to take care of them?
There is no one else. No one else at
Oh,
all.
my.
I just asked for just a little bit of
Oh my
understanding.
gosh.
I can guarantee you I will not make this mistake.
Ms. Rico, I think
Yeah, no. Are you working full time?
Yes, I am.
What do you do? A hairdresser? I'm sorry.
I'm a hairdresser.
Yeah,
Yes.
yeah. Listen, in order to post bail, you'd have to post a percentage of bail. And would you be able to post in the amount of $100?
I don't think so. I don't even have access to any of my bank information. I don't know. Like I said, I have to pay my power bill and my rent is due as well.
I understand.
And I get paid on Friday. And that was the plan, that on Friday that stuff would be paid. And unfortunately, the situation as it is, it's stopped me from being able to do that because no one else has access to my accounts or anything like that. They're just
Right. I'm going to take the extraordinary step in this case, which I normally would not do, but I'm concerned for your daughters. I don't know what they're going to do. If their power's off, they're struggling, they don't have anyone to turn to. I'm concerned for them. You should be concerned for them as well. And I know you are. Believe me, I know you are. You're their mom. But this behavior is showing a disregard for them, frankly. You get released on your own recognizance. You will obey all laws and you will consume no alcohol or drugs without a prescription. I'm placing you on enhanced supervision.
Thank you.
You are to report upon release to the Reno Municipal Court to sign up for the enhanced supervision. That must start immediately. Today, it has to be today. You are not to drive unless legal to drive. You may very well be legal to drive. Please don't misunderstand me that I'm prohibiting you from driving. Only prohibiting you from driving if it's not legal for you to drive. It probably isn't at this point because you refused testing, which means the police revoked your privilege to drive right then and there, and you don't get that privilege back for a year. That's between you and the DMV though. So call DMV, connect with them. They will tell you how you can be legal to drive. There is a way to do that, but you have to work with them, okay?
Yes.
All right. That's it. No slip ups, because this is serious business, and I will, if there's any violation, remand you into custody, and I will set a bail that will keep you in custody.
I understand.
Thank you.
Yeah, told you that one was tough. What do you guys think? Judge Stevens, I like Judge Stevens a lot. He puts up with a lot. A lot of the Reno judges do. Well, every one of the Reno judges put up with a lot. I call Reno Justice Court my Saturday morning cartoons for a reason. But some of his cases are really tough, and that one was tough. That was probably one of the most put together people I've seen in one of the Reno jails. But she's got a problem, and her kids are at home by herself. Now they're 16 and 17. I mean, I don't know, they're probably in school, so they're probably not working, so they can't pay the bills. Anyways, I'm gonna stop ranting about it. But let me know what you think. Do you think that she should have been let out on a PR bond or what? Just let me know. Let me know what you think. Last clip. Last clip is about 20 minutes. It's a little bit of a longer one. A little bit of a man-child going on here. All right, let's go.
Michigan versus Christopher Layman.
Good morning, Your Honor. Christopher Sasson appearing on behalf of the plaintiff.
Mr. Sasson, let's see, how about Christopher Layman?
How are you doing, Your Honor?
Good, Mr. Layman. And let's see. Have the two of you talked recently at all?
We have not, Your Honor.
No? It is set for
I
somebody.
did.
Go ahead, Mr. Layman.
Sorry. I did get a call from them saying if we could settle it so that before going to court on a lower price. They did call me and ask me that. I thought it was a little suspicious on why they wouldn't want to just go to court instead of saying I'll take a lower amount if you want to.
Okay. Well, you know what? That's in that decision is going to be totally up to you. Do you want to talk to the attorney in private for a minute before we proceed?
No.
No, just want to. Are you sure?
Yeah, I should be good. I appreciate it though, Your Honor.
Okay. This is set for motion for summary disposition today. Did you file a response to that motion?
Yes, I did, Your Honor.
Mr. Sasson, did you get a response to the motion? Sometimes
No,
I get confused with an answer to it.
We have received his answer to the complaint and his affirmative defenses, but our office has not received any response to plaintiff's motion for summary disposition.
All right. They do say how old he is. I think it's 20. He is young, but yeah, he looks like he could be a lot younger than that. I just want to throw that out there. I wouldn't be throwing anyone under the age of 18 onto my channel. So he is, I think 20. They do say it. Okay. Now I'm just rambling again. All right, let's go.
All right. There, I do have your answer to the complaint. Is that what you're talking about?
Yes.
Okay, so that's different than a response to the motion that's up for this morning as well.
Okay, I'm sorry.
Okay, so I'll tell you what, we'll proceed with the motion and see where we go. So I'll let you go ahead with your motion.
Thank you, Your Honor. Your Honor, this is plaintiff's motion for summary disposition, and it is brought pursuant to Michigan Court Rule 2.116C9, C10, and I1 for the reasons as set forth and discussed in both plaintiff's motion and attached brief in support. Your Honor, this is a subrogation action brought by the plaintiff against the defendant to recover reimbursement for damages caused as a result of an accident caused by the defendant with plaintiff's insured. On July 8th of 2022, plaintiff's insured was involved in an accident when the defendant was operating an off-road vehicle, an ATV type off-road vehicle, unregistered on a public highway. And subsequently, in attempting to negotiate a turn, the defendant struck plaintiff's insured caused damage to plaintiff's insured's vehicle. Plaintiff subsequently, pursuant to its contract of insurance with the insured, paid for that damage and seeks reimbursement. Now, the attached in support of plaintiff's motion for summary disposition is documentary evidence in support for the to recover the reimbursement of the damages. Plaintiff subsequently, as a result of the damage caused by the defendant, plaintiff's insured subsequently brought this action against the defendant, which alleges negligence. Count 1, as set forth in the complaint, includes negligence. Count 2, failure to maintain the requisite insurance under the no-fault insurance code. The defendant did file an answer to the complaint and disputes negligence. However, attached in support of plaintiff's motion for summary disposition as one of the bases is C10 is documentary evidence, which includes the following. First, Your Honor, in attached exhibit number 1 is the State of Michigan traffic crash report. As set forth in this report, the defendant was operating unit number 1, as set forth in the police report, was operating an off-road vehicle that the police report reflects as vehicle registration, none. The police report reflects hazard action, improper no signal. Additionally, there's also a narrative in the report, which reflects that while Unit 1 pulled over to stop on the south side of Arlene Drive, Unit 2 attempted to pass them, leaving some room. When Unit 2 passed, Unit 1 attempted to turn right across all lanes of traffic to get onto the trail on the north side of Arlene Drive. Where they did that, they struck Unit 2 on the side. Once Unit 1 hit Unit 2, he dropped his bike, causing minor injuries. So, Your Honor, it is plaintiff's position. The defendant is clearly negligent in attempting to negotiate a turn directly into the insured's vehicle. Additionally, there is statute on point as it relates to use of off-road vehicles. And particularly, I'm referencing to MCL 324.81122 subsection 3, which makes the defendant prima facie negligent if the defendant, in operating an off-the-road vehicle, fails to have the vehicle, that off-road vehicle registered, or if the individual operating that vehicle fails to negotiate a turn by not using a right angle. Particularly in MCL 324.81122 subsection 1 provides that a person shall not operate an ORV that is not registered under the code upon a street, county road, or highway, except as provided in section 81131 or under the following conditions or circumstances. A, the operator of a vehicle may cross a street, county road, or highway other than a limited access highway at right angles for the purpose of getting from one area to another, if the operation can be done in safety. The operator shall bring the vehicle to a complete stop before proceeding across the street, county road, or highway, and shall yield the right of way to oncoming traffic. Subsection 3 provides in a court action in this state if competent evidence demonstrates that a vehicle that is permitted to operate on a highway pursuant to the code is in a collision on a roadway with an ROV that is not registered under the code, the operator of the ORV involved in the collision shall be considered prima facie negligent. The attached documentary evidence in support of plaintiff's motion for summary disposition clearly demonstrates this ORV was not registered and that the defendant did not attempt to negotiate the turn. 1, did not yield to oncoming traffic, and 2, did not attempt to negotiate a right angle to safely negotiate the turn. It is also attached in support of plaintiff's motion for summary disposition as it relates to the damages incurred, Your Honor, is plaintiff's payment log, which reflects the payments that were made to the insured to reimburse it for the damage caused to the insured's vehicle. It is plaintiff's position, Your Honor, that the defendant has failed to file a written response in opposition to this motion, as one of the bases is a C10. Defendant's failed to file a written response in opposition to the motion and is required to do so. And additionally, the defendant has failed to proffer any documentary evidence to oppose plaintiff's motion, and as such is required to when one of the bases of a 2.116 motion is brought under C10. The defendants failed to do both, file a written response and to proffer any documentary evidence motion. So, Your Honor, for all the reasons as fully set forth and discussed in plaintiff's motion for summary disposition, and Your Honor, for all the reasons as orally presented to the court here today, plaintiff would respectfully request that the court grant the motion for the relief requested and enter an order of judgment accordingly. Thank you.
Okay. Mr. Layman, it's your turn. Anything you want to tell me?
Oh, there's definitely some things he wants to tell him. So what do you guys think so far? He's young. He's fighting it. I applaud him in that. He's trying. He's not just paying the ticket. He's trying. He doesn't do a very good job, but he does try. So can't fault him for that.
Yes. So I had an ORV sticker, and that is, you don't have to have nothing. You use an ORV sticker to cross to another trail. You can get on a public road to get to a trail, and that's what I was doing. I had my arm. So what he has is the first police report. I wasn't able to give my statement due to me going to the hospital due to my leg injury. So the officer was not able to get my statement. So I did go to the 67.
Before you go into all that, Mr. Layman, though, why didn't I have no response? I've got to follow what's in writing for the motion. No affidavits, no response to the motion. This is where you run a risk if you don't have a lawyer involved.
I've never been to court before.
I understand. So you should have had a lawyer.
Okay.
The big problem, sir. The biggest problem is with that 2.116C10 motion. You can't just rest on your laurels and tell me everything you want to tell me factually. You got to show me some kind of affidavit to support your claim or your defense.
I did go to the 67th District Court, and I did like written stuff. I don't know if you
your answer. I have your answer to the complaint, but that's not the same thing as a response to the motion.
Gotcha. I've never been to court, so didn't really know how it works. Sorry, Your Honor.
Yeah.
And I didn't have enough money to afford an attorney.
I see.
So,
how old are you?
I am 21.
Okay, not old enough to get yourself, I hate to say, into some trouble. Okay.
I've never been in trouble before, so. But also the other he has the first police report. I have the second one, and the second police report, the first one said improper no signal, and the officer changed that so it says no fault to either one of us. So, and I did give the 67th District Court the second police report as well, which has my statement on there and all that as well.
Sir, is somebody helping you out over there?
No. So
I hear somebody whispering. I hear somebody in the background. Who's
yeah, my mom just like she wasn't helping me out. She was just giving me the paper.
Yeah, she's helping you out. Is she an attorney?
No, she is not, sir.
Why don't you put her on the screen? Put her on the screen for a minute. Ma'am, you're his mom?
Yeah.
Ma'am, I can't have you coaching him. You're not an
I
attorney.
was just handing him the police report.
You got to be quiet, or I'm going to have you outside of the room, or I'm going to have to do this differently. Okay? All I hear is all this whispering. You can't do it. I'm sorry.
Okay. Sorry.
Okay?
Yep.
All right.
All right. Before we go on, Tommy's in the chat. If you're not subscribed to him, why not? It's the question I have. Why not? Also, since I'm shouting at people out, Sashina is live right now. Well, she actually might have just finished. I think she said she had 2 videos that are about 10 minutes apiece. I think that's what she said. Another great channel. So, Tommy, drop your link. Can someone drop Sashina's link as well? All right, let's finish this up.
I guess Mr. Song, did you receive a second traffic report? Was there a second one somewhere?
Your Honor, there is an addendum to the police report. Does Your Honor have plaintiff's trial brief?
I do. I just grabbed that. Is it?
Yes, it is contained in there as well. We've attached it to the to our trial brief.
Okay.
And the reflection, there is an addendum. There's a 2-page addendum.
Okay.
In the narrative does include, apparently this particular officer did subsequently speak with the defendant and does include the defendant's narrative.
Okay.
But I would add as well that there's nothing about the actual crash itself that changed. In the narrative portion, you'll see exactly as the first police report, the first witness statement that was taken from the officer explained. The second narrative also reflects the same description of events, that the defendant was attempting to negotiate a turn in which the defendant struck the insured's vehicle. Again, statute requires that the defendant, in operating the ORV, yield to oncoming traffic and negotiate a turn at a right angle. The defendant simply did not do that. It doesn't change the calculus or the sum of events. The defendant was negligent in operation of the vehicle.
Okay.
Can I say something, Your Honor?
You can, Mr. Lane. I'm going to ask you a question though. It's
Okay.
going to be up to you. Do you want me to review both police incident reports? I guess it's an addendum. Do you want me to review both of them before I make a decision?
Yes, please.
Okay, I'll do that for you. So what else did you want to tell me?
Okay, so the defendant went around me into oncoming traffic that is a no pass zone, and I was to a complete stop. I put my arm straight out to signal that I was turning left. It was not a right turn, it was a left turn to go onto the trail, and he went around me, and as I was at a complete stop, I had my arm out to turn. Soon when I went to turn, he was on the side of me, and I went over into his vehicle. He was in a no pass zone that went around me. He was not supposed to do that, Your Honor.
Okay. And I understand you're telling me that you've got some kind of a tag on the
Yes.
ATV, but it's not a license for the roadway, is it?
You can go on the roadway to a trail, which I was doing as I was turning to go to the trail.
Sounds like you were going parallel down the road.
I was turning left. I was right here, and the defendant was behind me. I was stopped right here signaling to turn left onto the trail, and he went around me, and that's how it happened. He wasn't supposed to go around me in a one-way.
So were you on the side of the road, or was it a 2-lane road, or what was it?
It's a 2-lane road, and yes, I was in the middle. Right, just because you're supposed to ride with like traffic, how a car rides. You're not supposed to go all the way over to the side of the road. You're supposed to stay in the middle of that lane. And I was stopped right there signaling to turn left because I don't have a clutch. So it's just automatic pretty much. So I signaled to turn left, and he went around me in a no pass zone.
Okay. Mr. Sisson, before I say anything you want to respond to, I'm giving him a little leeway because we don't have anything writing, but anything else?
Yes, Your Honor, thank you. Yeah, I believe just by the defendant's account, the defendant is admitting or conceding that he was operating that vehicle on a public street or public way as he's driving down the lane. Hence, the statute as set forth requires him to have that registered. And his failure to register it, and as the original police report and the addendum reflects, there was no vehicle registration. Number one. Number two, it's the defendant's obligation in operating the ORV to ensure, as the statute requires, the defendant to bring the vehicle to a complete stop before proceeding across the street, county road, or highway, and shall yield the right of way to oncoming traffic. And so the burden here is on the defendant to yield the right of way to the oncoming traffic. But again, it is plaintiff's position that his failure to have it registered is prima facie negligence per se. And so for all those reasons, Your Honor, respectfully, plaintiff would ask the court to grant plaintiff's motion for summary disposition.
Okay, given that I've got both police incident reports as well, I'll.
All right, you know what time it is. There's about 2 or 3 minutes left of this. This is when I peace out. Again, not leaving. I'm still here. I'm just not going to pause it anymore. So I'm just going to let it play out. So if you haven't done it already, please like and subscribe. Do your jump kick bat flips. If you would like to donate, the link to my link tree is in the description with all of my pay apps. But until next time, bye.
I'm going to take a brief recess off the monitor. I'll come right back on and make a decision for both of you. Okay?
Thank you,
Your Honor.
Sure.
Oh, man. All right. I didn't edit this out while they're thinking about it. I'm sorry.
Good, good. Okay, we can go back on the record with Automobile Club of Michigan versus Christopher Layman.
How are you doing, Your Honor?
You're good, good. I haven't had a chance to review all the pleadings and documentations that have been provided as well as been filed with the court. This motion being brought by plaintiff pursuant to MCR 2.116 C9, 10, and I1 to find, first of all, Mr. Layman, for your benefit, as well, based on MCR 2.116 C10, court determining factual support that exists, whether this claim exists or not by factual basis. Court must consider any pleadings, affidavits, depositions, admissions, and other documentary evidence provided. The non-movement party must not rest on mere allegations or denials of the pleadings, but must demonstrate by documentary evidence that there is a genuine issue set for trial. You do find, based upon all the pleadings, the attached documentation for the motion, and I gave you some leeway too, Mr. Layman, let you just kind of speak and tell me what your position is. I do find, though, that there's no genuine issue of material fact on this basis, and judgment should enter for plaintiff. I do find, based upon MCL 324.811, actually several statutes, MCR 324.81122 and 81131, primarily that the operator vehicle may cross the street or county road directly at a right angle. Do you find, by what you've told me, as well as the police reports that I gave you the benefit of reviewing the police incidents reports as well, that you were actually operating this ORV on the roadway and failed to yield right away, for one thing, but also, and being operating on a roadway, did not have the proper registration or license for that vehicle to be operating on a public roadway. That
was one of the police
Sir,
reports.
hold on, it's my turn. It's my turn now, okay? Therefore, it's prima facie evidence of negligence based upon statutory language, and I've given you the benefit of what factually had happened too, even though it's not in writing from your side, but all of the documentary evidence, everything in the file shows that there's a prima facie negligence action against you if you failed to register or failed to negotiate a turn. I do find that you are operating, based on your own statements, that you were operating in the roadway and either failed to merge or were not following this particular statute and following a direct right turn across the roadway. Therefore, it's a prima facie negligence claim against you. Find that, again, there's been no supportive evidence provided by defendant. Therefore, based upon MCR 2.116C9, 10, and I1, do find no genuine issue of material fact as well. Therefore, judgment for plaintiff based on summary disposition. For the amount stated, yes, Mr. Son, I had it in here.
Yes, Your Honor, I did. See
Five,
this proposed.
there, yeah, I've got it. $5,361.50 in damages, plus court costs for a total of $5,578.87.
That is accurate, Your Honor. Yes, thank you.
Okay. Grant judgment in those amounts. The court costs for Mr. Layman that are alleged $75 filing fee, motion fee of $20, service fee of $47.37. Those are statutory fees that are included in that total. I'll sign a judgment pursuant to summary disposition and send both of you a copy, okay?
Thank you, Your Honor.
Thank you. Good luck to you, Mr. Layman.
Thank you.
Yep, bye now.